Okay, we're recording now.
Shall we begin?
Sounds good.
Well, welcome to today's webinar, How Can Communities Cope Through the COVID Crisis? This is legal and insurance guidance. For the legal side, we have Todd Billy, who's a fellow of the College of Community Association Lawyers. Todd practices solely community association law and represents over 1,200, is that correct, Todd?
That's correct.
Of our 5,300 Missouri associations. And then there's me. I will be bringing you the insurance guidance. I'm Karen O'Connor, Corrigan. I have my designation as a community insurance and risk management specialist and provide services to over 500 communities in the metropolitan area. And then there's Kathy Roth-Johnson, our executive director. She is administering the webinar for us, and you can send questions through the Zoom operations, the functions, and she will collect those for the end of the presentation. And then Todd and I will answer the question. So with that, let's begin with the learning objectives. And the very first learning objective is going to be, are community associations an essential business? Todd will let us know the answer to that. There are three aspects to the operation of the community associations: the government, the business, and the social. The governance governance part will be about operating without in-person meetings and elections. The business part will contain maintenance and repair, what's essential. And then the social part will be the boards. The boards are in a very well-positioned spot to provide information. We will cover the insurance protection or lack thereof. Are there being uninsured decisions made by the community associations? We're going to touch on the recent federal legislation, and if there's any help for the community associations, and then a call to action by the community associations themselves. So with that, we're going to move on to Todd and ask him the very basic question: are community associations essential?
And the very simple answer is yes, because we facilitate housing. So it's very easy to think of a tower condominium association. Well, of course, we have to continue to operate, clean what we need to do the things we need to do. But even a basic HOA with a pool, which is where many of our questions come from, face these same issues. So a lot of it comes down to, well, how do we operate? How do we work within the three functions of an association on governance, business, and social? So Karen, if you want to hit the next slide, we'll hit governance. So right now we have the stay in place order for City of St. Louis County. That is going to be staying in place. We're not sure when that will be lifted. I know the City of Kansas City is the same, but other jurisdictions are already starting to phase those out. So even when the stay in place gets phased out, the question then becomes, well, is it really back to normal? The answer is no. Social distancing requirements are still going to be required. Having meetings just, with a typical 3-person board and a manager, now you're at 4. So it's not going to take much to get to the magic number of 10. So associations need to start managing how to govern, if they haven't already, how to govern and administer and make these decisions without being able to meet in person. For Missouri nonprofit corporations, there is a provision that allows a board to adopt emergency bylaws. And really what this does is it doesn't expand the scope of what a board can do in terms of its authority. It just provides the way for the board to operate, to remove the obstacles that would be in place regarding meetings. Associations that are not incorporated would need to, well, if you're drafting emergency bylaws or you're not incorporated, you will need to talk to your legal counsel to see what options are available for you. But for the vast majority of associations that we've helped, a lot of them are doing the virtual meeting resources. Elections are very, very tough to do that way. So a lot of them are shifting to simply going to mail-in ballots. but you have to have the emergency bylaws. You have to have the legal process to allow that to have legal validity. So the virtual meeting resources, again, they're here. A lot of them are free, and most of them are user-friendly. And as you saw, if you joined just a few minutes early, join early and play around with it and make sure you don't end up like the viral video where the lady ended up looking like a potato. So when we look at businesses, then we have to start looking at, well, okay, we can continue to operate. We need to operate. Now we have to start looking at what's essential that we do and what's emergency repairs. Emergency repairs, certainly in a condominium association, need to happen. Those things simply cannot stop. For example, you have a water leak. You have to address the water leak, but you have to do it as safely as possible. So when you're looking at emergency, you're going to have to work with the vendors and the contractors to make sure that's done as safe as possible. Fortunately, I know a lot of restoration companies, just because of the work that they do, they already have the ventilator type equipment that can help. So we may have to go that route to do it. But a unit that's been vacant for a while, there's no reason why a contractor cannot go in and make the repairs that are needed. Then we shift into essential and safety and what can be done that way. And that's where you start to get into the, well, look, if the work is being done outside, you know, we see the picture here of a landscaper, that can be done safely, and it's very easy to keep that up. Now, larger landscaping projects where you might have more staff, that doesn't make sense to do. And again, you would delay those types of projects. So the emergency repairs and the ability to respond always has to be there. All of the essential tasks that we do, the board has to make an informed decision with the vendors to see if this can be done safely. So Karen, if we go to the next slide, we start to look at these community facilities, and they do need to be taken one by one. Let's take elevators. Elevators have to be maintained. Same thing with the common lobbies. Those are not optional. Laundry facilities would be the same way, unless you happen to have a community where you know everyone has a washer dryer. That's not really an option. So you're going to maintain those things as essential parts of living. When you see the rest of the list, that's where it starts to get more complicated. Clubhouse, there's no reason to have it open. If you happen to have on-site staff and they happen to work in the clubhouse, it's much easier to close the clubhouse, allow staff to continue to operate out of that clubhouse in a safe manner. It protects both sides, especially with OSHA requirements where you still have to comply if they're your employee. You still have to make sure that they are safe and cleaning is being done. I know in St. Louis County, most tennis courts are already closed and locked up. Same thing with pools and sport courts. Walking paths is obviously a little bit more difficult, but since it's outside, it also provides a little bit more ability for us to maintain social distancing. Where sports courts, you know, if there's basketball, you're not going to practice social distancing if you're playing basketball. So those types of things, you have to make an informed decision on, looking at your community and understanding what would work for them. So but you know, in making that informed decision, it comes to Karen, which is, well, Karen, what are our risks?
So we get a lot of questions, and our greatest concern is that there are uninsured situations out there, and these decisions are being made without perhaps some guidance. Questions like from the board, we want to keep the pool closed, but we fear the lashback from the owners. Owners are asking for their money back, as though the association doesn't need the assessment income to maintain the rest of the business. This is not the YMCA. Question, should we close the sport court? The kids are out there playing basketball. What is your responsibility for the common hallways? So we're getting all those types of questions, and we want to help the insureds do the best they can, because there may not be insurance protection should they make the wrong decision. And to understand that, I would like to explain the basic insurance principles. It's based on the scale of large numbers. A large group of people pool their money to pay for the few that suffer a loss during a year. It's not suited to pay losses where all policyholders suffer the loss at the same time. And that's the reason why insurance all across the board excludes losses such as war, nuclear hazard, and virus. Because if they were to cover something that happens to everybody at the same time, they would become insolvent. One example is you are hearing on the news and maybe reading about how the legislation is trying to make its way to force the insurance companies to pay for business income losses, even though they're excluded. So if that were to happen, the industry itself has $800 billion of surplus set aside that the actuary said, we must set this aside this year based on the risks that we are insuring. Remember, virus was not one of those risks, so they didn't put enough aside for virus. The business income losses for those businesses under 100 employees is $250 billion to $430 billion, so it would eat up all of the insurance surplus that's out there for our covered losses, our fires, something terrible that might happen, an earthquake. So that's the basic principle. Now I want to get specific for our communities. You all have a general liability policy. And if you were to open the pool, we want you to understand the general liability policy is there to cover bodily injury, which includes disease, property damage, and libel slander. But it all gets covered under certain conditions. The first is that the association must be legally liable, and that is usually triggered by negligence. And there must be an occurrence, which is defined in the policy as an accident. And if we get past those two things, then we have to look to the exclusions. And one of the exclusions in every policy is expected or intended injury or damage. When we say injury, we can mean getting ill. So we certainly might expect that residents will become infected if they are gathering or touching surfaces at the pool. So this exclusion, you can see, could easily be implemented in any type of claim where an owner contracts the disease at the pool and alleges the association is responsible. The other exclusion that we'd have to get past is that many of the policies have the communicable disease exclusion, and so you can't get past that either. The answer is you really cannot rely on general liability insurance to protect the association for an expected contamination of a person. Then people think, well, we can fall back on our directors and officers liability insurance. Often they think it's a catch-all policy, that surely if the board is named personally in an allegation or a suit, the D&O policy is the one to respond. But that is not the case. If it has to do with an injury, it goes back to the general liability policy. If it has to do with a wrongful decision, it falls on the D&O. So D&O specifically excludes any claim arising as a result of bodily injury, including disease. And that's because bodily injury is intended to be covered by the general liability policy if it's at all a coverable situation. So we cannot rely on the D&O with respect to actually contracting the disease. That doesn't mean boards are paralyzed. They can make their own decisions. We just want them to make informed decisions. We read about a Massachusetts condominium building that decided to form a caring committee. So they are a single building and they want to encourage people to self-quarantine. And in doing so, they want to reward their owners with services such as those that are self-quarantined, such as dog walking, grocery shopping, trash pickup. They Zoom the quarantine person every evening or day, however much they want. Now, don't get me wrong, this condominium building did a lot of research. They went to Johns Hopkins Center for Disease Control and put together a strict protocol of how the volunteers handle these things. When they pick up the dog's leash is latched on to the door handle. Everything is wiped down immediately. The person is inside. There's never contact. They put all of this together, and the board sought legal guidance and learned that there is no insurance protection, most likely. But the board decided to go forward anyway. They thought it's in the best interest of their building to help people self-quarantine. So we just want you to make informed decisions. If you were to make a decision such as that, there could be a possible remedy under workers' compensation insurance. It does pay for illness. Every state's different. In Missouri, the volunteers are covered if they contract the disease during the course of work, and it has to be peculiar to that scope of work. Now, will the insurer want proof that the disease was contracted during association duties? Probably. So we never want to totally fall back on this. But if a committee member from that Massachusetts condo were to allege they contracted the disease during their course of duties, perhaps this would be a buffer for them, at least give them some financial assistance. I know that you all have been reading a lot about legislation trying to force insurance companies to pay for the business income losses that all the businesses are suffering. And I just want to touch on this lightly. The only way it would really affect a community association is that you are going to lose some income from rental of clubhouse, rentals of pools. Business income is triggered only when there is physical damage to the insured property. So that means the damage would actually have to be to the clubhouse itself or the pool itself. And the physical damage has to be caused from a covered cause of loss, like a fire, tornado, or burst pipe. And virus is explicitly excluded. And that is why the business income insurance has not been triggered for all of these situations out there. So with that, I'm going to get back to Todd, and he's going to let us know if an association has an affirmative duty to protect us from virus.
And generally, an association does not have a general duty related to safety or to keep someone healthy or safe from a virus. But when the association does undertake a task or obligation, such as cleaning the common areas, the elevators, you cannot do so in a negligent manner. So buildings with common hallways, elevators, lobbies should be considered for additional proactive measures, and it needs to be and should be documented. With Karen, Karen is going to, of course, part of Karen's job is to scare us a little bit, and then I get to scare you a little bit more here. When you do not have insurance coverage, and the association does what most reasonable people think they did everything they could, when you don't have insurance protection, there's two parts to it. One is if a lawsuit is filed, the association cannot look to the carrier to pay to defend that claim. So the association's resources are going to be needed to be used to litigate the case. And that has nothing to do with the merits. That has nothing to do with, oh, there's no way they'll be able to show it, just like the workers' comp person. It's very, very difficult, and it may be almost impossible to do it in a workers' comp situation because you have a worker coming and going. But when you have residents, and we can thank the government orders for this to stay in place, owners are staying in our communities. And if they are really, really isolated and the only place they go or have gone is the gym or tennis, and they play by themselves, there was nobody else involved, and then they contract it. For them, it's very, I think what we're going to hear a lot of is, well, where else could I have gotten it? I didn't go anywhere else. So the allegation, and oh, by the way, you can make a lawyer joke now. There are lawyers already out there nationwide looking for COVID-19 cases. So there's two parts. Well, one is we will have to defend these cases in-house. These cases, being medical in nature, are more difficult to litigate versus a slip and fall. So an association needs to be prepared to essentially pay its own way to defend that case. And then ultimately, if owner or resident or guest is successful, paying any judgment out of the association's proceeds. So Karen got just scary about insurance, and now I get to bring it full circle, which is you're paying full freight. And one of the reasons why we have not seen this before is it was almost impossible to show that because the association didn't clean something, I got the flu. Food poisoning is even difficult, and you know where you ate. So when the association does something, we want to make sure that everything's documented. You want to make the informed decision. But the key to understand on the businesses is, as a business component, the association would need to be prepared to defend itself against one of these lawsuits. And part of that is making sure we have income. So if we go to the next slide, associations, as Karen mentioned, business interruption is not vital income for the vast majority of community associations. Our income is assessments. And where's our, for lack of a better term, wiggle room or flexibility? It comes in the form of late fees, interest, and then perhaps delaying when you forward it to legal counsel. So going all the way back to over a decade ago in 2008, we wanted to do these same things. We want community associations to be proactive, to come up with solutions to these issues. Is it better to get paid assessments over a little bit longer time and not have to worry about late fees, interest, or paying an attorney? The answer is yes. So every community is going to be different as how they do it. Obviously, if they have already been sent to collections, you have to work with the attorney on how to do this. But the goal is to come up with different tiers and different categories for accounts, get proactive with with your owners in the associations, be reasonable and communicate clearly that, yes, you still have to pay your assessments. I'm sorry, we're not, and just to tease you, we don't necessarily have access to the other incentives that are out there for businesses. So please keep paying your assessments, but we are going to be reasonable and we're going to work with you.
Okay. Like Todd said, there is my job to bring you the doom and gloom, but there are going to be other situations where we hope you can find coverage, just not situations having to do with the actual contraction of the disease. But the D&O policy, if we have a really broad policy that covers non-monetary defense cost, is going to step in and help on other claims that we predict we will see. Foreclosures are now government protected. So what if the board is too aggressive with collections? What if the board discloses the name of an infected owner? We have privacy laws. That can't happen, but it could happen. What if the association breaches a contract due to lack of funds? So 6 months down the road, if we have a lot of owners that haven't been paying their assessments and the associations are just simply out of money, I can see that happening with a breach of contract. And then what about breach of fair housing regulations? We can imagine somebody closing a pool and there's an allegation that you're breaching our Fair Housing Act rights because I have a disabled child that relies on that pool for therapy. These types of claims can be covered by the D&O. Again, the directors and officers is meant to cover wrongful decisions, wrongful acts, not an injury. And that's what all of this is about. There is an exclusion in the D&O that this type of coverage is there unless there is purposeful violation of a statute or regulation. So we've got regulations out there right now. We want to make sure a board isn't purposefully violating them. Right now we have, I believe the mayor of Eureka wants to purposefully violate St. Louis County's ordinance to stay at home. Again, we can't do that type of thing as a board. Todd, we're going to come now into the social aspects of dealing with COVID.
Yeah, and one thing just to mention, just to show you the scope of D&O and to bring back a question you had earlier real quick, is, Karen had the side as well, owners are going to say, well, I want my money back. If you do not open the pool and an owner files a lawsuit saying you should have opened that pool, D&O coverage would likely defend you in that action, okay? So that's just, so D&O can still be a valuable tool to protect ourselves. So socially, so let's get together, but not really. So all online social events, CEI, the Heartland chapter, we've already been doing that. There's nothing wrong with doing that as a community level, whether it's a happy hour through a Zoom meeting. even if it's just organizing some type of online gaming, whether it's Words with Friends and you purposely go through. We're aware of others, some associations doing tree ribbons, they pick a color, they're doing signs, and yes, you may have to get some flexibility for signs to support each other. I know some communities that have a lot of children are doing urban safaris, so they will put certain animals in the window, so when people walk by, essentially it's a little scavenger hunt, you can take pictures of them. Karen also mentioned the great example of volunteering out of the condominium association in Massachusetts. While an association sponsored event would obviously take a lot more planning, there is nothing wrong with the association putting connections together, connecting people to make sure that they understand that while this isn't an association function or sponsored event, these avenues are out there. And when it comes to amenities and you can still use them, just maybe not for the intended purpose. So let's say you happen to have a lot of common ground. As long as you are following the social distancing guidelines, you are actually going to be okay. Now, you just may not be playing tennis, okay? So workout facilities, that's going to be much tougher to do. But it's all about finding different uses that we can do to still maintain some level of our social network, because, you know, as we've long said, the stronger sense of community you have, the less problems you have with enforcement, violations of those sorts, assessments, and those are the associations that typically rebound from challenges very, very quickly. So there's nothing wrong with getting creative, and then again, talking with your insurance professional, talking with legal counsel to make sure there's a way to do it safely and everyone is aware of all the risks that are involved. So this was put out by CI National, and this is just something that you could easily print out, and this is a way for neighbors to connect to each other. It's a great, simple way to stay connected with your neighbors. Certainly we used to, we're more used to it's hot during the summer, it's cold in the winter, so checking in on those that elderly or those that may have less ability to pay their bills on time, it's still just a way to connect to each other to make sure that everyone is safe and has essentially continuing to live their life as best they can. So social distancing, what can communities do? A lot of it, up here we have a couple slides or a couple photos of some social distancing, reducing visitors, keeping things to essential only. The key is making those connections. CDC, your local health department, we can absolutely be the center or the hub of the wheel to make sure all of our residents know what we are doing and where these resources are available, including, as Karen mentioned, if someone is having financial difficulties, we want them to reach out to us now so we're aware. We want to make sure that they at least explore opportunities with their mortgage companies to look at other ways to make sure it works. I know some mortgage companies are delaying mortgage payments automatically. Student loans have some relief right now because we're just not eligible for the government programs, and we're not built to just, I'm sorry, you don't have to pay assessments for 3 months. We're not built that way, we're not structured that way, but we can absolutely be the hub of that wheel to help build that sense of community so everyone knows what's expected of them and everyone is getting the valuable information that they should be getting. So legislative help, these are the first one is what's been in the news the most, the payroll protection program. And it ran out of money. It was actually just replenished. We're not seeing any tweaks yet. We're still digging through. It looks like they just threw money in it. Community associations are not eligible according to CI National. I am aware of one association that did get approved, but I don't know what the long-term implications of those are, as to whether the SBA just wasn't paying attention or if the SBA is actually going to allow associations to comply. Then you have the question as to whether it's a loan or a grant. If it's a grant, as at the very bottom of the slide, maybe you don't need owner approval. But at its very genesis, at the beginning, it is a loan. So you have to look at your governing documents to see, what requirements need to be done to take out that loan. Next, we have the Economic Injury Disaster Loan Assistance, or an EIDL loan. These are vast majority of the times, these are used in natural disasters out of whether it's California, Florida, tornadoes. It just hit the news that the SBA is not taking any more applications because of all of the funding through these loans. In other words, the request for money already exceeds how much money is set aside for these type of loans. An association, it does qualify, but you're still stuck with the issue of, do you need owner approval and what do your governing documents require? So in terms of other legislative help, there's two things. CEI National has already sent out a call to action. This is what the email looked like. So you can always contact your U.S. Congressperson or your U.S. senators to get them to make it clear that community associations are eligible for these types of programs. This way, we can help offset our losses, or at least make it more feasible for us to help out our owners that are going to be facing financial difficulty. In terms of what's going on in Jefferson City, we do not anticipate, and it's actually just hit the news recently as well, about immunity for businesses that are providing just basics, deliveries, groceries, the businesses that are deemed essential and open. Well, the question is, should these businesses be protected from liability from this disease? So we have in Jefferson City, CEI through MOLAC, we are aware that the merchants are trying to do that. Just as simple as, someone who has no symptoms, has no reason to even be able to be tested, and they hand you the bag through drive-through, and somehow the outside of that bag is the transmission point. No one's at fault. No one really knows how or why that happened, but it happened. Should the businesses be liable for that transmission? So the merchants are worried about it, and of course, we are looking to try to expand that scope so it would cover community associations. And a lot of the questions have come up about pools, because that's really where, it's one thing where we can clean, we're monitoring the cleaning, we know who's coming and going. It's another thing when it comes to those amenities or those areas of the community where we simply have less control over. And if two people accidentally don't social distance, what implications do those have?
So as Todd mentioned earlier, we want the board to be in a position to help the owners. Part of helping to collect your assessments is perhaps helping them not pay their mortgage, because it can be forgiven for 12 months if it is Fannie Mae or Freddie Mac backed and FHA. So they have both put out positions that they will forbear the mortgage for up to 12 months, waiving assessments and penalties and late fees. So what we want to provide to you are these websites, the actual website addresses, so that you can send them to your owners and help them learn everything that's out there for their protection, so that perhaps they will be able to make their assessment payment, which is what the association must have in order to keep going. There's some other community resources. This is from the CDC, the top one. It's titled Community, Schools, Workplaces, and Events. When you get into it, it gives guidance on how a community should handle things, school, workplace. And when you really look into it and drill down, when it talks about communities, it refers them back to the business methods of, keeping their places clean and following all the guidelines. So I don't think that community associations are just off the hook and not following the CDC guidelines. So this is a great reference for you. Another one is the foreclosure forbearance by state. This tells them what they have options by state. And then we have basic steps to take with form letter to members. Now this is put out by CAI National, and it's a great letter. It's a great template. As a board, you can fill in the processes that you plan on taking. Are you going to close the pool? This tells them why. You get to insert many different aspects of how you're going to treat COVID. And then the last one is a guidepost for collections and the actual collection process that you're going to be going through during COVID. Next, we have everything you can read about Todd Bailey and everything you can read about me. And that draws us to the end of the presentation, but we have saved a lot of time for questions. So we're hoping that Kathy Roth-Johnson will come back on and feed us any of the questions that have been put forth. And I think just to sum up everything that Todd and I said is basically that there is not going to be insurance protection should somebody get the injury and blame it, or the illness and disease, blame it on the association. But if you overreact and you shut down the pool or you shut down the fitness room and they called that unconstitutional or overstepping your authority, that's where you will have some insurance protection under the directors and officers. So there's no protection for the illness, but for the decisions and actions you take to prevent it, there can be protection. So Kathy?
Yes. First of all, there's been several people that have asked if we're going to share the PowerPoint slides, and we will. I will send those out to everyone after this is over. First question. We've been told there is a liability concern from opening a pool or clubhouse due to possible transmission of the virus. How could anyone prove where they contracted the disease and therefore hold the association responsible? Todd.
So this goes back to kind of the summary. If I've only stayed within the condo, and I can show that, whether it's deliveries, whatever, there's two parts to the claim. One is defending it and all the costs and attorney's fees related to it, and then it's, can they show it? Because of the lack of insurance, the risk of simply defending the case can even be more than the claim itself. If they had a somewhat mild case, and let's say, for lack of a better term, or for an example, their damages are $5,000. As you know, $5,000 in the litigation world is not much. So, but let's say it is unfortunately someone who's at high risk and passes away, and the family members want justice, or what they view as justice. They might be more willing to simply say, I'm sorry, the damages are extremely high. We are looking for a pound of flesh as well. And all those cases depend. So can they prove it? It's not necessarily easy, but it does become a lot easier if the only place they've ever gone and they can show it is our condo, and then the pool or the amenity. So it's those two parts that make it complicated.
Next question. Does our association need to carry some type of insurance for COVID-19? What type of uninsured decisions would be made, and to whom? The association or the homeowner, or both? Karen.
So yes, so there's not really any type of COVID insurance that's out there. You can't purchase something special. So the decisions that you're making are somewhat what we presented in the PowerPoint. You're deciding to leave the pool open and the illness is contracted. And again, like Todd said, it gets blamed on the association and not necessarily, you know, it's proven, maybe it is, maybe not, but the allegations are there and the allegations need defense. So with that, you're just putting yourself at risk. There is nothing you can literally go out and buy. And, you know, so the uninsured decisions are leaving the clubhouse open, the fitness room, the pool, anywhere where the disease can be tracked, the illness itself. Is that good, Kath? Well, we might have lost Kathy.
She just accidentally muted herself, that's all.
Oh. Or not. Or not.
Well, I have one of the other questions that was submitted early.
Okay.
Before. I would like to know thoughts on if there were social distancing requirements and pools open, allow residents to not abide. Is there any liability for the HOA and also the management company? Is there a recommendation on how to handle recommendations to boards that they choose not to follow? Should we have them sign a waiver and make a statement in the minutes? As Karen mentioned, this is really all about the board has to make an informed decision what to do with their pool. It is going to vary by jurisdiction and health departments. So for example, St. Louis County, the rumor mill is that pools are going to be a lot longer versus St. Charles County, which I believe they're looking to have open somewhat on time as long as there's social distancing requirements. If you're in Kansas City area, that's even more complicated because the city of Kansas City is staying with a stay in place, but parts of the city are in Clay County, and Clay County is going to start opening for business. So no board should assume that a signed waiver is going to be legally enforceable or effective. It may defer some from filing a lawsuit, but the association is still forced to litigate the issue at its own cost. This is the same concern that would be present if the association posted signs and warnings. If the association does open the pool and attempts to enforce social distancing requirements, the association has to do so in a reasonable manner. As a practical matter, each community is going to be different as to how that might work, but you have to start thinking about as to what that might look like. So, could you have scheduled swim times for a set number of residents? Do you have set areas of the pool used by a person or family that is quarantined together for no mingling? How do you handle constant supervision with the ability to contact the local police to, enforce it? Let's be realistic. If a manager is out there, it's no different from any other time. If a manager is out there or a lifeguard or even a board member and they say, you're not practicing social distancing, you're placing people at risk, we have to have a way to enforce that. And if the police department is not willing to do so, then that places everybody else at risk. So again, making the informed decision based upon the individual circumstances of your community is all we can do. There's not going to be any universal rules on this one.
I'm sorry, guys, I'm back. Had technical difficulty. Next question. I have an association where declarations state all meetings are open to the owners. How would we dismiss owners when we move to executive session? This would be difficult through conference call through Zoom.
So what we would suggest is essentially the associations should completely close out of Zoom and have a separate meeting, or truly separate the executive session. So do the executive session beforehand, exclude the owners and the residents, log out, log back in, and then restart the open portion of the meeting. That's, as a practical way, that's probably as good as it's going to get. Fortunately, by having some association functions just slow down. Yes, you can discuss contracts, but there's no reason to enter in a contract if you're not sure when they can start doing the work. So inherently, you can have a little bit more distance or time in between the executive session and perhaps the regular open portion of the meeting.
Karen, can you make the distinction between opening the pool, for example, starting up the pool equipment for the year, as opposed to opening the pool for owner's use? This has been a huge source of confusion and frustration for board members.
Yes, so I believe that this might be referencing, did this question come from a manager, Kathy?
It did.
Okay, this might be referencing the fact that certain ordinances are requiring the opening of the pool to deter from stagnant water throughout the summer. So we're still going to have those costs to open the pool and look at it looking nice and pretty and not be able to use it. And that's going to cause so many questions for the board. The board is going to have to answer to that. And again, I would send you to that CAI national letter the form letter, the template, communication is going to be key in all of this. So if you can communicate that the ordinances require us to open, we are spending the minimal amount to keep it maintained. It's not as though we have people swimming in there where we need chemicals changed every day. We're spending the minimal amount, but we can't open it up to the owners, because if we do and we are told that somebody contracted the disease there, we wouldn't have insurance protection. So why not have some transparency? Just share it with the owners with communication.
Next question. We have a pond we just stocked. Can we do social distancing fishing?
The board has to look at the risks and the way to implement it to allow that amenity to be used in a safe way, as well as some mechanism for enforcement. Maybe some more, it's not too often you see a fisher, someone fishing by themselves. Now, if it's a family, that's okay, because they're quarantined together. So it's any type of amenity that would be available, just like the walking path. I think it's at least reasonable that there should be warnings to owners. If you're going to use this amenity, it's your obligation to social distance. It does not protect you against the claim, but at least it's easier for us as lawyers to defend the association, saying that's outside. There is no way for us as a practical matter to keep you from walking the path or walking or using the pond. So we've at least warned you.
Next question. I manage an HOA in Eureka. They have a pool, which is in St. Louis County. Do we follow Eureka if the mayor lifts the stay-at-home order, or follow St. Louis County's guidelines?
Generally, what I would suggest is that you follow what's most, whatever is harshest, for lack of a better term, under these circumstances. I believe the permitting in St. Louis County is all completely done by St. Louis County Department of Health and not the city of Eureka. But in general, if one person says, yes, you can, one says, no, you can't, have the conversation for the lawyer, make sure you're on the same page. But usually it's always safer to follow we're going to follow the most stringent regulation or ordinance that applies.
Next question. I have a pool that has no lifeguard. Would it be a good idea not to put chairs out? And what about closing the bathrooms?
It's my understanding if a pool is open, you have to have the bathrooms open. I think this all goes down to the board talking with the pool vendor, talking with legal counsel, talking to their insurance professional to make that informed decision as to what they can and cannot do if they choose to open it. I like here's an example I can give you. Just this morning, I found out, I am very thankful and appreciative. It is not a board member of a client of mine, but I am aware of a board member who wanted to have a meeting, and just because of a lack of scheduling, they didn't meet in person. They did it over the phone, and over the phone, the board member said, oh, well, I have COVID-19. It's not that bad. So we cannot, my ultimate fear is we cannot expect people to social distance in a pool or a gym or a tennis court or basketball court. I think so it becomes a legal challenge to find a way to make it work where these amenities can still be used and we're all on the same page as to what the risks are to everybody. So if you're going to have the pool open, I think it would be reasonable to have where the chair is going to be, who's going to regulate who uses them, how is that going to be assigned out, what's the cleaning routine going to be. The pool itself, the water, that's not the concern. It is the chairs, the surfaces. Sunlight doesn't, the virus doesn't like sunlight or humidity. That's great, but we're not there yet. We're not in the middle of the summer. We don't have those protections yet. So, whether we like it or not, at first it was don't worry about the face masks. Now please wear the face masks. So it is a absolute minefield. Sadly, the only way we're going to know what the right and perfect decision is going to be is in a couple of years from now when we're past all of this.
Next question. Has any illness ever been covered under insurance? Think about Ebola or food poisoning on site at the clubhouse or pool area. Why is COVID-19 any different?
So yes, especially food poisoning. I mean, that's it's a product that they put out, the restaurant put out, and somebody gets ill from it. They can typically, it's still typical to prove, but there are a lot of protocol about it. It usually happens within the first 24 hours. Did they report it? Things like that. But that is covered under general liability insurance. COVID is different because of the pure basic principles of insurance that is supposed to be spread of risk. Again, large pools of money are gathered to take care of the few incidents, catastrophic incidents that we have during the years, the fires, the tornadoes, the hail, all of that. And therefore, any widespread type of situation that can happen, such as war, nuclear hazard, and virus, are excluded from insurance. The insurance industry would be insolvent if they had to pay for something that happened to everybody at once.
Last question, I think. Where do we need to get to before getting ill at the pool is no longer expected?
That is a decision that we have to see how everything unfolds. We don't, as what the term you're seeing a lot on the news is data, flattening the curve, things like that. Absent everyone magically being tested at the same time, so we know who has what and who they've talked to and all of that, we'll never be really ahead of the game, and we will always have a level of chasing this down as to what these risks are. So is there a point where we can say it is entirely safe to use the pool? It's very unlikely that we would get there.
I'm sorry, we got a few more questions. If pools were to open, but with social distancing protocols, how is the board to ensure that the pool area is maintained social distancing if not monitored regularly? Is it detailed signs with regulations and specifications at your own risk significant? Also, if the pool were to open with guidelines, would the board then be liable to hire a company to sanitize the pool furniture, locks, pool gates, etc.? Should associations open pools if they are allowed to in the near future? It keeps going, so I'll probably send this to you guys because it's a pretty long question, but I'll leave those few questions for you.
When it comes to the pool, it's the same as any other amenity. If it's not essential and you open it, because that's the real distinction. If it's essential, you have to have the elevators running. If it's not essential and you're going to allow it to be open, you have to take reasonable steps to make sure that it's safe. So in the context of a pool or a gym, you're going to have to do regular cleaning and documenting it. You're going to have to show that you have some way or some plan to enforce social distancing requirements. Those are the things that are needed to really deter someone from filing a lawsuit, because that is the risk. I'm not overly concerned about the merits of the case. I'm worried about having to defend 10 of these. And if you're defending 10 of these, even at 10 grand, $10,000, and that's cheap in the litigation world, that's still money that could have been used elsewhere. So trying to protect the association's resources, but those risks really come down to, if you're going to open it, the warning signs, great idea, may not work legally. It may deter the lawsuit, but it's absolutely no guarantee against the lawsuit. The only way to ensure that the association is not exposed to liability would be a state statute that says an association is not liable for transmission of these types of diseases. And until that statute is there and there's no insurance coverage, these are the risks we face.
Todd, would that apply for like clubhouses for like exercise equipment, elevator buttons? Should they be hiring someone like a cleaning company to come clean those areas?
Yeah, so most associations with elevators already have some type of cleaning, whether because there's going to be a common area related to usually, the lobby area. Yes, the association should be cleaning those common areas. They should have a clear schedule. Owners should all know the schedule, and it should be done as frequently as OSHA requests, which I believe is, if owners are truly staying in place, you want to have it done, really as often as you can. It also depends on your size and how many people are in that building. So there is no universal, hey, every hour you have to do it. Some businesses were that way right before the stay in place. They would literally close for so many minutes during an hour so they could go and clean. So because we have stay in place common areas, you're doing your best, you're keeping it clear. The reason why a common area is going to be a little bit different than the pool area is we already have people coming and going, and we can't say, don't use your hallway. That's not an option. So the courts I think what will happen is the courts are going to make the distinction as, wait a second, in this type of housing, there can be no liability for areas where the government said you have to be allowed to go. Whereas a pool, we like a pool. I'm sorry, it's not essential. Karen gave the example of a child that may have a disability or someone with a disability. That's going to go through legal counsel. But a pool is not essential to housing.
I think this is the last one. Boards hire people to work on units. Should associations notify residents, distance themselves, and if residents claim COVID-19 left behind, is that a problem?
For the associations that have a higher density, a lot of them have already informed owners that unless it's essential, no contracting work is being done by the association. Nothing should be done inside your units. So I'll give you an example of someone sympathetic. They purchased the unit and they closed right before the stay in place order went in. Well, moving into a condo may fall into the exceptions, may not. There's this open question. So for those types of activities, what we do is we want to make sure owners are aware that this work is being done. So in this case, all the owners were made aware that this person was moving in. They were limited to what doorway they could come in, and they had to clean afterwards. So it allowed the owners to know that there was more of a risk because people were coming in other that are not quarantined. And then we followed right up with the cleaning. So this way the owners can make an informed decision of themselves as to, well, I know the movers were just here. I think I'm going to wait another hour or two before I go in the hallway. If a unit is vacant and they want to have work done, same approach. It's safe to do inside the unit. Now we're looking at, okay, how do we look at getting or allowing them to come and go in a very safe manner? And a lot of it is going to depend upon how the community is set up, whether it's essential or not, or whether it can be, the project can wait.
Two more questions. Can we continue to practice standard collection of assessments and charge late fees?
You can. The question is whether or not you should, and that is up to the board.
Okay, next question. Confirming Zoom meetings doesn't constitute a quorum, but more informational, and then would said ballots and not vote on Zoom?
So the question is, it depends on, just to drill that down a little bit, it's really going to depend on what decisions are being made. Obviously, annual meetings, we have people coming, we have candidates, we have paper ballots, we maybe have proxies coming in. Obviously with quorum and wanting to have people there, you're going to blow through the 10. The absolute max you can have is 10, even after the stay in place statewide expires with the local one still in place. So that's where you have to talk to the attorney to make sure what can you do to carry out that election. For the few associations that happen to have them scheduled, they've consulted with me and we have figured out a way to handle those meetings, handle those votes without having those in-person meetings. For board meetings, you know, the everyday paying bills, there's, you know, just a quorum requirement for the board. And that's usually a majority of the board members. So those can still operate. I'm hoping most owners will use, and most boards will use those meetings to, hey, we're going to spend the first 10 minutes paying our bills. Then we have some light housekeeping on updates. And then the rest of it is devoted to, here's things we can do to help each other. Again, whether it's the mortgage forbearance, looking out for those, the social types of events I mentioned before, where in person is required, and understanding what's everyone need throughout their community.
That's the last question. I want to thank Todd and Karen for both presenting our first webinar. I also wanted to let people know, a lot of people have asked, can we share this webinar with their board members? Absolutely. We should have the recording sometime later this week. Todd and Karen, do you guys have anything else to add?
Yes. So we understand, Todd and I, that this was a general overface of everything, and it's a lot to take in. We couldn't drill down on every single topic. So we want you to know that the Heartland chapter is planning for the next webinar on May 13th at 10 a.m. They will drill down into pools and other high touch areas. We expect guests such as the mayor of Creve Coeur and a representative from the city of O'Fallon. So, you know, we think that you're going to have even more questions, and we understand that we couldn't answer everything in an hour, but we thank you so much for your attention, and please stay healthy and safe, and we look forward to when we can see you again.
Bye, everyone.
Bye.
Stay well.
Stay well.
Bye.